Agyarko and Ikuga and the Secretary of State for the Home Department.
Good afternoon, my lady and my lords.
Good afternoon.
I think when we concluded yesterday, I'd moved on to part 2 of my submissions addressing the domestic law.
Yes.
And we'd looked at Ambrose and Harris and EB Kosovo. What I'd like to do today, Mr. Saini and I have agreed that as I gave him some extra time yesterday, I should have until 3 o'clock this afternoon, and I'll try and make the best use of that time and go through things in a fairly structured way. I'd like to deal with Razgar, Huang and Quila, albeit I hope I can do that relatively briefly. We will need to go back from time to time just to look at the Strasbourg cases to see how they marry up, but I don't think that will take too long. And then I can deal, I think, very briefly with Chikwamba, Zambrano and Durecci and the facts of each case. We largely covered the scheme of the rules and the guidance yesterday, but I shall just go back to that briefly to make sure you have the page references conveniently to hand for all of the material that was in force at the relevant time. I hope that sounds a sensible way of dealing with things. So, in terms of the domestic cases, we could start with Razgar, which you have at volume 2 of the authorities, tab 14. It starts at MS 484. And for our purposes, the key passage is at MS 505. Between letters D and G, that's the sort of starting 4 or 5 lines in from paragraph 17 and through to the first few lines of paragraph 18. In a case, I'm starting at the end of the line, 3 lines down from letter D, in a case where removal is resisted in reliance on Article 8, these questions are likely to be, and then the very well-known 5 questions are set out. But the first is, will the proposed removal be an interference by a public authority with the exercise of the applicant's right? And it's only once one gets past that one's looking for justification. So I say there's nothing in Razgar that's inconsistent with our suggested approach, or the approach that we say now derives from Jeunesse. Huang is also in volume 2. That's at tab 18. Starting at MS 660, and we say that for present purposes the key passages are on pages 679, sorry, MS page 679 to 680. If I can pick it up on the 3rd line down from paragraph 18, the line beginning with the words Article 8, while the case law of the... well, I think we could probably read from the beginning of that paragraph. The authority must, of course, take account, as enjoined by Section 2 of the 1998 Act, of Strasbourg jurisprudence on the meaning and effect of Article 8. While the case law of the Strasbourg Court is not strictly binding, it's been held that courts and tribunals should, in the absence of special circumstances, follow the clear and constant jurisprudence, and citation to Alconbury and Uller. And Lord Bingham continues, it is unnecessary for present purposes to attempt to summarise the Convention jurisprudence on Article 8, save to record that the article imposes on Member States not only a negative duty to refrain from unjustified interference with a person's right to respect for his or her family, but also a positive duty to show respect for it. The reported cases are of value in showing where, in many different factual situations, the Strasbourg Court, as the ultimate guardian of convention rights, has drawn the line, thus guiding national authorities in making their own decisions. The main importance of the case law is in illuminating the core value which Article 8 exists to protect. He then again follows through the structured analysis that's been adopted and deals expressly with proportionality on the facing page, having said at the end of paragraph 18, proportionality is a subject of such importance as to require separate treatment. And if I could pick it up at paragraph 20, In an Article 8 case where this question is reached, the ultimate question for the Appellate Immigration Authority is whether the refusal of leave to enter or remain in circumstances where the life of the family cannot reasonably be expected to be enjoyed elsewhere, taking full account of all considerations weighing in favour of the refusal, prejudices the family life of the applicant in a manner sufficiently serious to amount to a breach of the fundamental right protected by Article 8. If the answer to this question is affirmative, the refusal is unlawful and the authority must so decide. It is not necessary that the Appellate Immigration Authority, directing itself along the lines indicated in this opinion, need ask in addition whether the case meets a test of exceptionality, and that's what's always cited against us. And my point, I've already made it in the previous appeals, but it's a short one. We accept that there is no additional test of exceptionality. What Lord Bingham did not do there was look at the Strasbourg case law in detail and say, even where, on the Strasbourg approach, exceptionality is an integral part of the Article 8 test, the domestic courts shouldn't follow that. And we say that in non-settled cases where family life has been created in circumstances of precariousness, it is now very clear that the Strasbourg court incorporates exceptionality into the Article 8 analysis. And it's not a question of asking, is there a breach of Article 8 plus something exceptional? In that particular category of case, and this doesn't affect the criminal deportation cases, it doesn't affect Bulti, Funa and Maslov, we also haven't seen exceptionality as a test in the left behind child case. But in this category, in the cases of leave to enter or remain as a partner, where a relationship has been embarked upon and developed in precarious circumstances, there is clear and consistent case law, most recently in Jeunesse, saying that exceptionality is what one looks for. So again...
So the all-important question is whether you enjoy the label of settled migrant.
Yes, and I'd say it was more than a label, it's about the substance.
Presumably, that there may be many cases where people who can't claim that label or status may have a far more well-developed family life than those who might have it. But notwithstanding that, on your submission, they are in a class where they must overcome this exceptionality hurdle.
They are, my lord, yes, because it's not a label. The court's looking at the substance. Is the state trying to withdraw rights it has previously granted? And of course, I'm not saying that the length of residence and the length of the family life and the closeness of the ties is irrelevant. As we've seen, looking at the case...
Well, I'm not suggesting that you're saying it's...
They're very weighty factors when one comes to look at exceptional circumstances.
Oh, yes, I agree with that.
And one looks at it under that rubric.
But you're saying that that particular category of person, whether you resile from my use of the perhaps pejorative term label, but certainly status doesn't seem to me to be exceptional. If you don't have the status of a settled migrant, then you have an additional hurdle from those who do enjoy that status.
Yes, the approach is different in the two classes of case. And as I say, if the case is one of left behind children, there's no exceptionality requirement. Sorry, I've moved away from the microphone. But there is in the cases of precarious family life. And in my submission, as the court knows, that's really clear from the decided cases.
And what's the rationale for, I think you can give a rationale for distinguishing between the left behind children and the family life established in circumstances of precariousness cases. Well, how would you put the rationale for that?
I think the rationale is twofold. Firstly, it's not a precariousness case because the relationship is not a relationship that was entered into in circumstances where there was an obvious immigration obstacle to the family living together. That's the first point. It's probably the key point, but also what's emerged since the beginning of that line of cases is the particular weight that the Strasbourg Court accords to the best interests of children. And that's an additional reinforcement in my submission for the already established principle that you don't need to show exceptionality in left behind children cases.
There might be an element of precariousness, it occurs to me, if you migrate for work-related purposes or whatever, not knowing whether or not you're going to be allowed to bring your whole family with you, including the children you already have. That might be the situation.
It might, and we'll look in a moment at IAA, which is the most recent of the left behind children cases, and indeed is a case involving the UK, which is, as you know, was only handed down by the Strasbourg Court, I think, about 10 days ago. Yes, I mean, the court will, I mean, it has its well-established principles, and then it will look to see how the facts fit within those. But it does, as I think has repeatedly been said, reiterate those established principles. And it's fair to say that there were a number of cases where the Strasbourg Court said we don't really need to decide on the facts of this case, whether this is a negative or positive obligation case. But Jeunesse has now made it clear that settled migrant cases are positive obligation cases, not cases of an interference.
I've been looking this morning at Karen Reid's textbook, which is a particularly good one, and she deals separately with cases to do with spouses and other partners and cases to do with children, and treats the, as I've understood her, she's treating the precariousness issue as being an issue to do with relationships with spouses and other partners, and Article 8 issues concerning children as being in a different, as being approached in a different way.
Yes, I'd accept that. I mean, the reasoning is different. And of course here, in my submission, by it's plain, we're only dealing with the partnership formed in precarious circumstances sort of case. And that's all I'm inviting this court to deal with in these judgments, because this does seem to me that these are all quite difficult and complex areas, and that it can sometimes be dangerous to stray beyond the immediate facts of the cases before the court. And I certainly have not researched other areas in nearly as much detail. So that's all I'd say about Wang. Should I then turn to Quila? That's in volume 3 of the authorities, at tab 32. MS 1102. And I'd like to pick that up at MS 1121. We've looked at it before in the previous appeals, so I'll take it relatively briefly. At paragraph 33, the court records that Mr. Angus McCulloch, QC, on behalf of the Secretary of State, relied on Abdulaziz. Paragraphs 33 and 34 then deal with the Court of Appeal's basis for distinguishing Abdulaziz and says it's accepted by everybody that wasn't right. That's at the end of paragraph 33, the last sentence. And at 35, my Lord Wilson starts off with addressing the importance of the decision for present purposes. And he says that is the route by which the court came to reject the complaint under Article 8 alone. The majority held that Article 8 wasn't engaged. And then at 37, Lord Wilson said there are 4 decisions of the Court of Human Rights subsequent to Abdulaziz which deserve attention. The first is Gull and Switzerland, and the court applied the decision in Abdulaziz, as we see 2 lines below the letter D, the line beginning with the word family life. Although, therefore, the court applied the decision in the Abdulaziz case, it stressed and then dealt with the facts, and then Lord Wilson then addresses the powerful dissenting opinion. We've got Gull in the bundle of authorities, and it's in the additional documents at MS 3423. And very, very briefly, it's right to say that at 3433, paragraph 42, the Commission had analysed the case as an interference case. But then at 3438 to 3439, the Court's reasoning is rather different. At 34, I'm sorry, am I going too fast? So the MS numbers don't always run in sequence in the bundles, but it's MS 3438 if one's got it. So paragraph 34, it is necessary to ascertain whether there was interference by the Swiss authorities with the applicant's right under Article 8. And then from 35 onwards, the Court looks at the facts, and it concludes at 43, having regard to all these considerations, and while acknowledging that the Gulf family's situation is very difficult from the human point of view, the Court finds that Switzerland has not failed to fulfil the obligations arising under Article 8.1, and there has therefore been no interference in the applicant's family life within the meaning of that article. So it deals with it as a no-interference case, not as an interference that's justified. And it is, of course, quite right to say that there were dissenting judgments, but that was the judgment of the majority. The next case that was looked at in Quila was Bulteef. That's at paragraph 39. I'm back to, Authorities Bundle, Volume 3, tab 32, MS 1122. Paragraph 39. And as we've seen, Bulteef was one of the line of criminal deportation cases involving settled migrants, which the court in Jeunesse distinguished. The third case is Overleaf, MS 1123, to Kwabo Tekle, and that was a left-behind child case. Could I pick up paragraph 40 just next to letter B? It's the line beginning with the words 6 of its members. And as Lord Wilson pointed out, the Court observed at paragraphs 41 and 42 that the asserted obligation of the state was positive, but boundaries between the state's positive and negative obligations under this provision do not lend themselves to precise definition, and that the applicable principles are nonetheless similar. Now, we've seen it saying that, the Court saying that in several occasions, but it did address this as a positive obligation case. And my Lord Wilson had asked yesterday whether we had copies, and we didn't have at the time. We sent them through electronically to you. I don't know if everybody's got them or if anyone would like hard copies, because we've got those as well.
Oh, I think I'd like a hard copy. I always like everything that's going, hard or soft.
There are some other additional documents.
Yeah.
One of the court staff's coming.
Sorry, what are you referring to now?
The case of Kwabo Tekle, which was sent through electronically this
Yes,
morning.
I've got it, yeah.
Hard copies are coming up. And could I just ask you to look at paragraphs 33 The applicants complain that the Netherlands authorities had not complied with the positive obligation inherent in Article 8. Then 38. The government, while accepting that family life within the meaning of Article 8.1 existed between Mrs. Kwabo Tekle and Meret, were of the view that their authorities did not have a positive obligation to grant Meret a provisional residence visa. Then at 41, the court notes that it is not in dispute between the parties that there's family life. What divides the parties is the question of whether or not Article 8 imposed upon the respondent state a positive obligation. And then at 50, sorry, it's a long paragraph. It's about halfway between the hole punches, there's a line beginning with the word although. Although Mrs. Tukwabo Tekle disagreed with the choices made for Meret, she was unable to do anything about them as long as her daughter was living in Eritrea. The court agrees with the government that the applicant's arguments in this context do not by themselves warrant the conclusion that the state is under a positive obligation to allow Meret to reside in the Netherlands, but it did go on to find that in the light of other circumstances, cumulatively, striking a fair balance did require that the daughter be given a residence permit, but it's all being looked at in the context of a positive obligation.
You'll remember yesterday I asked for this authority because I was interested in the phrase major impediment.
Yes.
We've got that at paragraph 48, haven't we, Miss Giovanetti?
My Lord.
Now, as you pointed out, this is about the entry of a child. It isn't about the expulsion of a partner.
No, it isn't.
I do understand that, but when you come to the very recent UK decision, you will see an apparent equivalence being suggested by the court of insurmountable obstacles and major impediments.
Yes, I was
That's
going
as
to
far
go
as
to
we
that.
can take that.
It is, my Lord. I absolutely agree.
Very
yes.
well.
And I'll give the page reference to IAA in a few moments.
Yes.
That's absolutely right. And then finally, Rodriguez de Silva, and in the last paragraph, so it's paragraph 41 of Quila, in the last sentence of paragraph 41, as Lord Wilson observes, again, the court had found that the breach was of a positive rather than a negative obligation. It's entirely fair to say that there had been a number of authorities that were equivocal at the least, about the significance of the distinction between positive and negative obligations. And at the time of Quila, Lord Wilson concluded at 43 next to letter G that there is no clear and consistent jurisprudence of the court which our courts ought to follow. And what I say shortly is that Jeunesse has since made it quite clear that the positive-negative obligation distinction remains a live one, and that in non-settled cases they are still to be analysed as positive obligation cases.
Well, are you saying that it assumes a greater significance or importance in this context? I mean, there are other contexts in which positive and negative obligations are considered, and in those different contexts, there certainly are suggestions that the significance between the two is not substantial. Are you saying that in this particular context, one should attach a greater significance to it?
I am, my lord, and I am for a number of interlinked reasons. The first is that it gives coherence to the fact that in precarious cases, the court's looking for exceptional circumstances. Because when you're looking at a positive obligation, rather than expecting the state to justify its interference, you're looking at the circumstances of the individual to see if those circumstances are sufficiently compelling to give rise to a positive obligation. So the entire analysis is starting from a different position. So in an individual case, it's part of the analysis. It may be that so long as one applies the exceptional circumstances test, it won't make an enormous difference in an individual case whether one looks at it as a positive or negative obligation. It's a step on the route. Where it is significant is not so much in the context of these two appeals, but in the context of cases like and SJ, where the challenge is to government immigration policy. Because, as you will recall from the last case, Mr. Justice Blake felt that Quila required him to depart from the previous approach of the Strasbourg court and the domestic courts, which was to say a very restrained approach to the requirements of immigration policy and looking to individual cases to see what Article 8 required. And he felt that the Secretary of State should be called upon to justify strictly all the requirements in the immigration rules because those rules were a colossal interference with the family life rights of the people seeking entry and their partners. And that was the route he used to embark upon what was, with no disrespect to him, but effectively a wholesale rewriting of the immigration rules, saying that the financial requirements should be lower, you should have a shorter period for assessment. I mean, the courts had never done that, and he acknowledged that, and he acknowledged that there was no basis in the Strasbourg jurisprudence for doing that, and nor had there been any basis in the domestic jurisprudence until Quiller. Now, it may be that he read too much into Quiller. I don't really need to deal with that, because all I say is that post-Jeunesse, it is quite plain that the proper analysis is not that immigration policy is an interference with the rights of non-settled migrants, that one looks at individual cases and one starts from the position that it's part of the state's sovereign right to have an immigration policy.
Well, in circumstances in which these two appellants say that the state has an obligation under Article 8 not to remove them from the UK, why, as a matter of interest, you say that is a positive obligation rather than a negative obligation?
Well, the very, very short point is that, as has emerged yesterday quite clearly, this isn't a removal case. These are applicants who are asking for the grant of residence rights. So just on that narrow analysis. But generally, the whole thrust of the Strasbourg case law is that people who have not been granted a right of settlement and who seek it, whether on an application for entry clearance from abroad or an application when they're here but without status, that is properly, for Article 8 purposes, to be analysed as a request or an assertion of a positive obligation on the part of the state. And as I say, I accept. I think Lady Hale at some point, I was going to turn to her judgment in a moment, but she says that the distinction is not clear and may have vanished in the case law. And it's quite right to say, as I say, that there are a number of cases where the court said it wasn't important on the facts. And I wouldn't be standing here making this submission had the Grand Chamber not said, quite unequivocally in my submission last year, that the distinction was live.
Part of that is that the reasons for respecting the policy of the state are going to be different.
Yes, that's the point.
In that when one's got a question of whether somebody should be given the right to enter or stay, there are questions of immigration control. And as you say, the right of every state to control the entry of aliens, foreigners to the state. The interesting thing about Quiller, and indeed, I think just about every case up until possibly now, is that the government has never said it is our policy to keep out spouses or to deter people from marrying foreigners. They have never said that. The whole point about Quiller was, of course, that the purpose of the policy was to deter or prevent forced marriages, as to which it was a very large sledgehammer to crack a tiny nut, and not necessarily hitting the right nut anyway. So that's what Quiller was about. And in our previous two cases, the one about the language requirement and the one about the financial requirement, again, the government has not said it is our policy to keep out foreign spouses. They have said it is our policy to promote their integration when they get here. That's the language requirement. And it is our policy to make sure they're not a burden on the state until they acquire settled status, which is the financial requirement. But what is the purpose of a policy that says we are not going to let these people who happen to have been here for quite a long time and acquired a family life, I think you do have to address, even if it's not a justification case, I think you have to address what the purpose of the policy is.
Yes. My lady, in my submission, it is fairly and squarely the maintenance of immigration control. And immigration control is not just about keeping people out. It's about deciding the basis upon which you're going to let people in. And maybe the best I can do to illuminate that certainly that is the approach the Strasbourg Court adopts is to take you again to Biao, which we looked at towards the end of the last hearing. You may recall that was the case about the relative length of residence in Denmark. And you've got that in volume 6 of the authorities.
The point I was trying to put to you is that immigration control is a very compendious phrase,
It is.
and it could mean anything, whereas different bits of immigration control one might have thought would have different purposes. That was the point that I was putting you. And just straight, bland immigration control is perhaps, especially in a context where it has traditionally been the case to permit foreign spouses to join their settled or citizen spouses here. That's what I'm getting at.
But in certain circumstances, there have always been restrictions because...
Yeah, but not very many.
Well, then
Not very many. I mean, the restrictions
degree.
have generally been no recourse to public funds.
Yes. Because part of the purpose of immigration control generally is to protect the public purse.
We're not quarrelling with that.
No, but there are a variety of purposes, and they're not distinct. You can't say this rule serves this purpose and that rule serves that purpose. There will often be an interlinking between them. So what we have in terms of entry clearance and leave to remain is a scheme of rules which include the language requirement, which include financial requirements, which include things like a provision saying you can't rely on third-party funds, because what the Secretary of State's purpose is to ensure that people are going to be self-reliant and independent and have a sound financial basis for their lives going forward. And what the Strasbourg Court does is look at all of that as part of the system of immigration control.
Do we have evidence in this case as to what the purpose is of only allowing people who are here, overstayers basically, to claim Article 8 rights if there are insurmountable obstacles? Do we have any evidence as to what the purpose is? Because in most of these cases, we have had evidence.
Yes. No, with the greatest respect, I dealt with the scheme yesterday, but maybe not in sufficient detail, because that's how it's put against me. It's not the way it operates. In Volume 1 of the authorities, you will see that the insurmountable obstacles criterion is not an additional requirement. It allows the relaxation, the non-application. So, sorry, if we just turn to it very briefly.
We do understand that. We do understand.
What it says is exemption from the normal eligibility requirements.
But we still need to know why those normal entry requirements deny the possibility of qualifying in the ordinary way to people who happen to be here as overstayers.
I can do no better than to say, in my respectful submission, it is self-evident. The rules generally require that people should be financially independent, should have some command of the English language. The Secretary of State is prepared to relax those rules in certain circumstances, including where somebody is here unlawfully, but there are insurmountable obstacles to the couple relocating abroad. And this is a more generous provision. As we saw from Chikwamba, in the past, they had to go abroad and apply from abroad. That was the general rule. These rules have relaxed that requirement, but in a narrow category of cases. It is a concession. And it was done, as I explained yesterday, for the purpose of encouraging people who are living underground with no immigration status, without papers, unable to work, to come out of the woodwork and regularise their status. And it's been, as we see from the statistics, significantly successful in doing that. I can't say better than that.
So the policy is to expect people whose visas have expired to go through the normal channels for an extension of visa or a right to remain indefinitely.
Yes.
And the policy is against people who don't do that,
yes,
but who develop relationships and then turn round and say that as a result of those, they can achieve the same through another route.
Precisely, I think it's what the Strasbourg Court has sometimes described as a fait accompli. And we relax that where there are insurmountable obstacles. So it doesn't matter if it's a fait accompli case, if it's an illegal entry case or an unlawful overstaying case. If there are insurmountable obstacles, they don't need to go through the process of showing the ordinary requirements are met. Just before I depart from my Lady Hale's question, could I just take you to the bit of Biao that I'd marked up and I was going to go back to? It's at volume 6 of the authorities.
Which tab, please?
Sorry,
So
tab 74.
Before we leave Quiller, I mean, the submission is that insofar as, apart from Lord Brown, all members of the court, with a very strong concurring judgment from my lady, said that there was a substantial interference. That, in retrospect, turns out to be wrong.
Yes.
Thank you.
But I do completely accept what my lady said, that there were lots of other reasons why the court was concerned, that it concluded it was a sledgehammer to crack a nut, that it was more to do with forced marriages than the control of...
Well, my recollection is that I did confront this issue of between positive and negative obligation, but pointed out, firstly, that they had become largely assimilated, as appeared to be the case then, and secondly, that the additional factor was immigration control,
Yes.
but the Secretary of State was not justifying this on the basis of immigration control.
I was going to go back to your judgment, but you have just summarised it in one
That's what I said.
Absolutely,
wasn't it?
yes.
Yeah. And I don't
Yeah.
think you'd have any quarrel with that.
No, I don't at all. And I accept that the distinction appeared to have been a diminishing one, but it's now quite plain that the distinction remains, and it may, in this context particularly, be a very important one.
Well, I just wonder whether that's right. I mean, in effect, does your argument not resolve the question that it doesn't really matter whether it's positive or negative obligations, because no form of obligation is animated in these circumstances?
Well, it plainly mattered very much to Mr. Justice Blake,
Well, it
who
may
said,
well have done.
I wouldn't be able to
No,
rewrite...
We've moved on
Yeah.
through various stages from Mr. Justice Blake's judgment. What I understand you to say now, in this case, is that the Article 8 right is not in play here.
Yes.
And if it's not in play, then whether the obligation that the state owes can be characterized as positive or negative is essentially irrelevant.
Well, I wouldn't go quite so far as to say it's not in play, because there's no dispute that we're looking at genuine family life, and that it's open to claimants to say, the UK has a positive obligation to allow me to enter or to allow me to remain. And that has to be considered properly by the Secretary of State. It's subject to...
Right, so, but once the conclusion is reached that there's no positive obligation to allow you to remain, so runs your argument, well then the whole question of whether it's a positive obligation or a negative obligation falls away. Sure.
Well, there just is no obligation.
Yeah,
Yeah.
there's no obligation.
There's no positive obligation, and if it's, if the court wants to say there's no interference, I'm entirely content
But
with
you're
that.
using positive obligation, I think, in a very different way from the normal discussion about the significance of the difference between the two. I mean, the significance of the difference between the two proceeds on the premise that there is some form of obligation, and there is lots of authority, lots of judicial comment to the effect that the difference may be vanishingly small. But your argument, as it seems to me, takes an anterior stance, and that is that unless you can show that there is a positive obligation to the route into Article 8, well, then the whole question of what the content of the positive obligation may be and what its difference may be from negative obligation is essentially irrelevant.
Well, I'm not sure that I can address the body of case law my Lord's talking about, because I'm not quite clear what it is. But it seems to me that the analysis is, and it may be that this does or does not meet my Lord's question, where where there is a right to respect, so in the present context, for example, where the United Kingdom has allowed somebody to settle here and establish a family life, any interference with that right has to be justified. And one has to go through the Rasgar steps of saying, is it in accordance with the law? Does it serve a legitimate aim? Is it proportionate? But where there is no such right, I'm not saying there's no family life, but there's no right for the purposes of Article 8, then the question is a different one. It's, do the circumstances give rise to a positive obligation on the part of the state to confer rights that don't presently exist?
Isn't
Or to recognise?
Yeah, is it not that there is, of course, where there is family life, there is a right to respect for family life. But what does that right include? I think we have moved from Abdulaziz to that extent, that there is, of course, where you have a husband and wife, automatically a right to respect for their family life. But does that right entail a positive obligation to respect it by letting them live together here?
Yes.
Isn't that the question?
Yes. Yes, and in some circumstances, the question will be, will the interference by deporting the person who's committed a crime, is it justified and proportionate? So, yes, I agree. There is a family life that has a right to respect, but the respect does not include, save in exceptional circumstances, an obligation to grant residence or refrain from removal.
Can I suggest to you, Ms. Giovannetti, from a practical point of view, if we suggest to tribunals that there is a vitally important distinction between positive and negative obligations, and they've got to decide into which category the case falls, that would be a recipe for disaster. Where the distinction, whether you approach the matter as one raising the question whether there is an obligation to, under Article 8.1, positive obligation, in other words, whether a fair balance has been struck for that purpose, or whether, on the other hand, there has been, whether there is a justification for interference under Article 8.2, I'm not sure that that is really where the point bites. I mean, where it really bites, I think, is that the criteria you apply are somewhat different in the two cases, yes, as we see if we compare the Jeunesse criteria with the Bultif criteria. And generally, although there's a good deal of overlap, some of the elements, such as the precariousness aspect and insurmountable obstacles that one finds in Jeunesse, are obviously weighting the balance more favourably to the community interest rather than the individual interest. And it may be there's a wider margin of appreciation also in that context than in the Bultif situation. I wonder, is that perhaps a fair way of putting it, of trying to encourage tribunals to focus on the appropriate criteria based essentially on whether somebody is a lawful settled migrant or not, rather than worrying too much about categorizing the case as positive or negative?
I'm not sure I'd accept that it's a recipe for disaster. I mean, all we're doing is trying to apply the Strasbourg case law, and that's what the Secretary of State conscientiously tries to do in her guidance. And in my respectful submission, it's more of a recipe for disaster to blur the distinctions in the Strasbourg case law, because it does tend to lead to errors in approach. And
But what would the error be? I mean, the only practical result is which set of criteria you apply. And that essentially depends on the lawfulness of the residence.
in an individual case, I accept that, but it's not difficult to say deporting somebody who's got indefinite leave to remain is an interference that must be justified, and entry clearance cases or people who are seeking a right of residence are asking for a right and need to justify why that right should be granted to them. And as I say, the reason I think it's particularly important is whatever this court says is probably going to be guiding not just tribunals and decision makers, but the Court of Appeal and the Administrative Court for years to come. And we've seen, I am not trying in any way to be disrespectful to Mr. Justice Blake, who is very experienced in this area and was loyally trying to follow Quila, but it led to an awful muddle where he felt that his conscientious discharge of his role meant that he required the Secretary of State to justify each aspect of her policy, and if he felt that the justification wasn't strong enough, he could hold it ought to be lowered. And that's the sort of hot water one gets into when you look at it as an interference which requires justification. The Strasbourg Court has not had very much difficulty in saying, let's look at the facts and see if they call for the grant of residence. And
well, it says that it says itself that it's not an easy. The boundaries are unclear, and there are cases, Nunes and Norway, for example, where it said it's not necessary for us to decide which side of the coin this is.
oh, absolutely, it has said that because it's just gone straight on to the exceptional circumstances are necessary. But we haven't been following that approach, and that's because the domestic courts have been saying, yes, that might be what Strasbourg does, but the domestic case law doesn't do that. The domestic case law says we have to go through the Rasgar steps, it's an interference, look at proportionality, how has the Secretary of State justified it? And in an individual case, it's very easy to say, well, the maintenance of a fair immigration control doesn't really require the removal of this woman. She's been here a long time, it's a genuine relationship, and it's not the right question. And when we look at IAA in a moment, which we will do, it's just an example of where not doing it in a rigorous way, in my respectful submission, has led to problems. I'm so sorry, I'm not sure how well I've answered the question, but I've tried to. Could I take you to the one paragraph of Biao before we go any further? It's MS page number 2369, under the heading Comparative Law.
We're looking at, sorry?
Sorry. It's the case of Biao, which is in volume 6 of the authorities. It's a 2014 case involving the attachment requirement in Denmark, volume 6.
What's the status of this judgment?
Tab 74. Well, it's the chamber judgment. As I told you last time, it's been referred to the Grand Chamber.
Thought, yes.
I checked last night to see if there'd been any progress, but there hasn't been. And as I understand it, it's the discrimination aspect, Article 14, which troubled the court more, which will have led to its reference. That's certainly my reading of matters. We looked at the reasoning in the MM and SJ cases, and I'm not going to go back to that. But just in an attempt to make good my point that Strasbourg regards just the whole bundle of criteria as being part of immigration control, could I ask you to look at paragraph 40, MS 2369, which sets out the very wide range of conditions that different states impose for granting family reunion. Notably, as I think Lord Brown pointed out in Quila, there are a number of other countries, I'd say other, we don't anymore, but there are countries that require that spouses should have reached either 18 or 21 years of age. There are language requirements. Some countries specify shouldn't have link with extremist or terrorist structures or with organised crime. So the conditions are very variable, but there is no case that I'm aware of or that you've been shown where the Strasbourg Court has said this condition is a disproportionate interference. It's too rigorous, it's too strict. And as we saw in Jeunesse yesterday, the approach of Strasbourg is that states are entitled to have strict, indeed very strict, conditions for granting entry, as long as they conscientiously look at the facts of individual cases to see if they justify relaxing those criteria. I'm going to have to go through the rest of my submissions very, very quickly indeed. BB, could I just say about that, I won't even take you to it. It's in volume 3, tab 34. In my respectful submission, Lady Hale absolutely correctly summarises the effect of Jeunesse at paragraph 1248.
Paragraph.
Oh, it's not
I'm so sorry.
1248.
MS 1248. I've written the paragraph numbers for the others and I didn't for that. I'm so sorry.
Oh, it's
We've got the
MS
reference.
Yeah. Thank you. However, the court did drift back into analysing things by reference to interference at paragraph 52, MS 1255, and paragraph 79, 1261.
Yes, and what about 29 at 1249, Ms. Giovanetti?
I hadn't turned it up because I was just conscious
I know
of
you're
time,
in
so
a
I will
hurry.
do.
Forgive me.
Oh, no,
Very,
oh, my
very
Lord,
quickly.
forgive me for not dealing with things more efficiently.
Not a bit. But at 28, my lady, this is only 5 months ago, I think I'm right in saying, deals with jeunesse.
Yes.
And at 29, although Strasbourg analyses these cases in terms of a fair balance, in this country we have, at least since Huang and Quilla, spelled out the principles in conventional proportionality terms.
Yes.
Now, we must rethink that in your submission?
In cases where there's no interference, one doesn't get beyond step 1 of the 5-stage Rasgar analysis of proportionality. That's my submission.
How do...
In other words, yes.
Yes.
But if one's left just asking, is there a fair balance struck? It's a very unstructured approach at first sight.
Well, it would be were it not for the fact that actually, in these cases, the court goes on to say, was family life started in precarious circumstances, and if so, you need exceptional circumstances. And whilst it hasn't closed the door to there being another category, apart from the left-behind child cases, over the course of 20 years, it doesn't seem to have identified any other category. So the non-settled cases are almost by definition precarious. So it's not just... I think I started off yesterday by saying the whole of the convention is a search for a fair balance, and I absolutely accept that if that's all one was asking, is there a fair balance, it would be a very wide and broad test, and a very difficult one to apply consistently. But when one sees that in this context, the question is, are there exceptional circumstances? And one could be guided, as Lord Bingham said, by the way the Strasbourg Court has identified things in terms of what's exceptional and what isn't, then it as has been repeatedly said since Huang, one has to adopt a fact-sensitive approach, and that's the guidance there is, and it's the guidance that needs to be applied. As to reasonableness, I just wanted to return very briefly to a question posed to me by Lord Hodge yesterday afternoon, which was, does it matter if we call it reasonableness, as long as we take the context into account, and that what is reasonable may vary enormously from one context to another. And I still accept that that's fine, except that reasonableness has posed problems in the past, and you've heard from a number of appellants in this court, that they all analyse reasonableness as being a very much more generous test. And unfortunately, that reflects the approach that has been adopted in the past by the tribunal. And that emerged, I think, very clearly from IAA. And you've got that, in the appellant's additional documents, MS 3577, at paragraph 44 of the court's reasoning, that's on MS page number 3588. And in this case, 2 of the applicants had previously succeeded on an appeal and had been admitted. This application involved the remaining siblings. At paragraph 44, could I pick it up on the 7th line down, which begins with the words appeal was remitted to it? And the Strasbourg Court says, however, in considering whether the applicant's mother could reasonably relocate, the tribunal applied a lower standard than the test of insurmountable obstacles or major impediments commonly applied by this court. Applying its own test, the court considers that while it would undoubtedly be difficult for the applicant's mother to relocate to Ethiopia, there's no evidence before it to suggest that there will be any insurmountable obstacles or major impediments to her doing so. So my submission is that I don't like the idea, and I don't think it's helpful to have sort of a ban on the use of certain words. And for a while, the use of the word unreasonable was generally heralded as an error of law if it ever appeared. It's not the right approach. Similarly, I don't say it's an error of law to approach things on the basis that the question is it reasonable? But it's important to emphasise the context, and that in the present context, in precarious cases, the standard of reasonableness is very high and demanding.
I don't think I was suggesting otherwise.
No, I don't think you were, but I just wanted to emphasise it
yes.
is important to...
But because taking up Lord Reid's point, it's what goes into the fair balance. And what you're saying is whether we call it a special rule for positive obligations or whether we say in precarious cases the weight attached to the public interest in maintaining control over immigration, including numbers, is given a special weight. Yeah. The result will be the same.
Yes. And I think that's what Mr. Justice Sales was saying in Nargray when he was saying that Lord Bingham wasn't intending to be canonical when he used the word reasonable. But unfortunately, people can pick up a word and run with it, and then it ends up not being interpreted in the way the court intended at all.
I see your problem.
If I could just give you, I've got about a minute left, the page references for the rest of my submissions, and I rely, I'm pleased to say, very largely on what's in writing already. So for part 3 of my submissions, that was going to be the scheme, rules plus guidance. Just so you have it conveniently in one place, the relevant provisions of the rules are in Authorities Volume 1, Tab 5, MS 69 to 73, which sets out the general requirements, and then Section EX, which sets out the exemption from those requirements, is at MS 76. As to the guidance at the time, that's at MS 3275 to 3277. The guidance currently in force is in Volume 1, Tab 10, MS 348 to 350.
That's the current guidance, is it?
Yes.
No, I got muddled. I thought it was tab 11.
Yes, it is tab 11.
Oh, I'm so sorry. There we are.
Right, now
I'm entirely wrong.
It's one, you're equal, you both made the same mistake.
Oh, yes, I'm so sorry. Yes, that's the one I'd marked up, but I don't know why I called it tab 10. It is tab 11. I apologise. It's the August 2015 guidance. So my helpful page references weren't very helpful in that instance. Part 4 of my submissions was going to address Chikwamba. The Court of Appeal dealt with the Chikwamba argument at paragraphs 31 and 34 to 35 of its decision. That's at MS 2487 to 9. We say the court was correct for the reasons they gave, which were largely the reasons that my Lord Reid put to my learned friend Mr. Saini in the course of his submissions, namely that, that's Zambrano Diretto, forgive me. On Chikwamba, I've got nothing to add to our case, which is at MS 3214 to 3216. Part 5 of my submissions was going to be Zambrano and Diretto. That was raised before the Court of Appeal by Ms. Ikuga in her skeleton, or the skeleton on her behalf, in one paragraph. That's at MS 2584. It was raised as part of the Chikwamba argument. Mr. Saini was mistaken to say that it hadn't been addressed by Mr. Sheldon. It was addressed in the Secretary of State's skeleton argument at MS 2659 to 60. As Mr. Saini very fairly accepted yesterday, didn't form part of the oral submissions, perhaps unsurprisingly, because the answer is, this is where the answer is, what my Lord Reid put to him yesterday in his submissions, which is that Zambrano and Diretto are concerned with dependent children who would effectively be forced to give up their own residence rights if the parent was removed. And I accept that that's not an absolutist rule, and you might have circumstances where you had an adult who was, for example, severely disabled and totally dependent on the foreign national spouse, where you can see there might be room for an application of Zambrano Diretto, but it certainly isn't applicable in cases like these. And we address that in our further subs at MS 3626. Finally, the facts. The applications are in the appendix part 2. At pages, I don't think my part 2 doesn't have MS numbers, but it's pages 256 and 426.
256 and
426.
426.
The refusal letters are in the core volume at MS 2721 and 2723, and then also at 2724 and 2726. And I'm very grateful to Mr. Sheldon, who has dealt with this comprehensively, I think, in our written case, and I won't seek to add to that. It's at paragraphs 102 to 121. The MS references are 3207 to 3214. And I'm so sorry I've strayed over by 4 minutes.
Can I just ask you one point? Do you anywhere deal with why and how far all this matters following the 2014 Act?
No.
And
I mean, in the previous appeals, the court gave us a very clear steer, I think, from the start of the criminal deportation appeals, that the 2014 Act was for another day, in Lord Newburger's words. So
well, I look forward to this. Thank you.
I won't say that I do, but unless there are any other questions I could address. Thank you very much.
It would appear not. Thank you very much, Ms. Giovanetti. Mr. Sheldon.
Thank you, my lady. Nothing.
We do realise you've played a very large part in these cases, so not to be diminished by the fact that you haven't actually said anything today. Mr. Saini.
Thank you, my lady. My lords and lady, as can be seen now that we have received all the submissions from the respondent, in my humble submission, it's clear that she is attempting to overturn a variety of House of Lords decisions. Those include Quila, BB, EB Kosovo, Razgar, and Huang. And I will say so for the following reasons. It's simply because it said that they don't follow anymore because of a distinction between positive and negative obligations, which is, in my humble submission, a false one. And I'll turn straight away to a little supplementary piece of material that was handed up today. I hope my lords and lady have it. It should look roughly like this. It's a little table that I had compiled based on my submissions yesterday. Now, this table, as it says, and is self-entitled, charts the history of the fair balance genealogy, if I can put it that way, from 1996 in Gull all the way through to IAA, promulgated just a week and a half ago, roughly. So I've given the various paragraph numbers where the fair balance issue has been given, and also where it has been disposed of as far as possible. I've given the MS numbers and the volumes and occasions as well. The point I make in short is the fair balance theorem first originated from Judge Martin's dissenting opinion in Gull versus Switzerland. That much is absolutely clear because the reasons he gave in dissent were adopted by the majority in Armut, Bulteef, Konstantinov, Rodriguez de Silva. Now, you'll notice from these authorities that they involve settled and non-settled migrants. So the distinction that the Secretary of State seeks to draw between two various categories of migrants is completely false and hollow, because ultimately Strasbourg itself seems to be unclear on the difference between the two, because what it comes down to at the end of the day is there a fair balance? Has there been a taking into account on weighting of the rights of the individual against the rights of the state in each and every example that you hear that is in the authorities' volumes? So it's clear you can trace the fair balance all the way back for 20 years. Nothing has changed whatsoever since the courts last looked at this issue. And in my respectful submission, that is also supported by IAA. I won't turn your attention to the authority, but I've given 4 different paragraphs where the Strasbourg court has just a week and a half ago mentioned the fair balance test in the context of a non-settled migrant, and therefore there is no basis upon which my learned friend can maintain or sustain her submission that it is now that we should depart from the fair balance exercise in light of Jeunesse. So, with due respect to my learned friend, and if you'll forgive the pun, overturning all of these authorities is an insurmountable obstacle which she cannot overcome. And so, with that in mind, it's also important, I say, to look at the effect that the new rules have. And those are to not mirror the Strasbourg jurisprudence as the respondent claims. I made a submission yesterday in terms of ELTRP 1.1, which appears at MS 120 and 121 of Volume 1. And in that appears the rule which my learned friend was forced to accept, demonstrates clearly that EX1 is not all as it seems, and there is something afoot here. Briefly turning to MS 120 and 121 in Volume 1, to be clear on what I say, if we look at 120 to start with, these are the requirements for limited leave to remain as a partner. The requirements to be met are, as we can see, A and B are fairly mundane. There must be a partner, there must be an application. Of course there must. Then if we go to C, the applicant must not fall for refusal under the suitability and also eligibility requirements. And, importantly, EX1 has not been applied. I say that's important because it makes clear that if you meet the rules and the criteria, as the Secretary of State has raised the bar, she won't mind issuing you with a permit. But if, on the other hand, as it says at subparagraph D, if you cannot meet all the requirements, and this is Roman D2, of ELTRP, then it can only be if Roman 3, EX1 applies, that you will still be given leave to remain. So this is clearly a category wherein the Secretary of State has sought to cater for settled migrants and non-settled migrants. So to now say, before this court, and of course I say this argument wasn't raised at the Court of Appeal at all, to now say and mount this argument all of a sudden that this must be what's happening here, that there's a differentiation, which is why the rules have been drafted in this manner, completely doesn't follow, because the rules themselves dictate that this applies to all foreign migrants, settled and non-settled. So the submission is completely false. In terms, briefly, and I say very briefly because my learned friend also didn't have opportunity to deal with this in as much detail, in terms of the Harrison and Dorici authorities that have been handed up today, I would direct the panel's attention, and I can't turn, I apologise to all of this immediately, to paragraph 68 of Harrison. There may be time. If I can, we'll just turn to that authority briefly. It's in the little bundle that my learned friend kindly had produced today.
Tab 79.
That is correct, my lord. So if we look at paragraph 68 of Harrison, very briefly, it's clear from this decision that the Court of Appeal, in its discussion, is saying within this paragraph, it's unclear what would engage the ratio from Zambrano. It isn't precisely clear because of the reasons given below that it would have applied in that particular matter, but if one looks and turns back a page to paragraph 55(1), what the Secretary of State and the appellants in that matter did agree is that the application of the Zambrano test requires the court to focus on the question of whether, as a matter of reality, the citizen would be obliged to give up residence and move beyond the European Union. So it's a question of obligation and it's a question of reality. So if we then turn, with that in mind, that's the only thing that could really have been agreed, to Dorici, which is at tab 78, and in particular, paragraph 68 of Dorici, which is at, there are MS numbers fortuitously, 3684. It's clear from this paragraph, from the Grand Chamber's decision, that the mere fact that it might be desirable to a national of a member state for economic reasons or in order to keep his family together to rely upon that ratio isn't sufficient. But it's a question of desirability was all that the applicants were able to posit at the door of the Grand Chamber. I simply want this to happen. Nothing more than that. It's what I desire. So it's a question thus far of obligations and desire. Turning from there to paragraph 74, which is the ultimate conclusion reached, it's clear that the key question is that the effect of the state's decision should not lead to the denial of genuine enjoyment of the substance of the rights of a citizen. That echoes precisely the ratio Zambrano. But that leads to the next question, which is, what are the substance of a citizen's rights? Now, I say, clearly, if you're a British citizen, you have a choice of residence and where you would wish to live. That is an intrinsic and inherent right of being a citizen of any country, because you have an inalienable right of abode. With that in mind, and reflecting upon the guidance which we looked at yesterday, the guidance makes clear that there is no question of a choice involved. And I'll just briefly turn to that to make good that submission.
Sorry, what are we getting from De Ricci?
We're getting from De Ricci that you must protect the substance of one's rights, and you must do so in a realistic way. It's a question of reality, and it's a question of whether the citizen, as a result of the state's decision, is obliged to leave the European Union. So with that in mind, I'm turning my Lord's attention and my Lady's attention to the guidance. That guidance appears in the Appellant's appendix. Additional volume, forgive me. And that is at pages 19 to 92. The MS number in particular is MS 3275. So it is unfortunate that my learned friend and I were fairly confused about the guidance yesterday, because I erroneously retreated from my position, which was that the guidance did not say what it did about British citizens, but in fact it actually does, because this is the May 2013 guidance. I think my Lord Hughes observed anyhow, but if we can see at the bottom of page 3275, it says there the same wording we saw yesterday. For example, a British citizen partner who's lived in the UK all their life, speaks only English, may not wish to uproot. But that does not amount to an insurmountable obstacle. So the implication of this mandatory guidance, which of course has to be met in order for one to succeed under the rules, is that you cannot take into account the wishes of the citizen in terms of where they want to live and whether they do not wish to uproot and move halfway around the world.
It doesn't say you can't take account of them, it just says it won't be good enough.
Well, it won't be good enough as an insurmountable obstacle,
Yeah.
but if you are going to take account of the wishes of the citizen, my lord, outside the rules, in terms of exceptional circumstances, the guidance is clear that if something exceptional can't be a near miss of the rules, and it has to be something over and above what's already covered by the rules. So if the rules have covered your choice, and they say that's not a good example, the rules, the guidance outside the rules should say, or ought to say, well, we've denigrated or asked you to ignore the choice or the wish of the British citizen because it's not an insurmountable obstacle in our opinion, but now would you please take it into account? Because in fact we might just be obliging them to leave the European Union in breach of Zambrano and De Ricci. So the point here is, would a citizen, seeing this guidance and receiving a decision that says, in effect, you need to uproot and move halfway around the world, would they think to themselves, well, I do feel obliged now to leave my country and home? And the answer is clearly that there is something that it's not just a mere insinuation here, there's something nefarious happening here, and it is that the citizens' rights are not being looked at or being given any respect or weight at all. So I say that is the natural outcome of the Zambrano ratio, and the reason why I brought it to the court's attention, notwithstanding the submissions I've already made about AB Jamaica and VW Uganda, and that, in the words of my Lord Justice Sedley, that you can't, of course, give nothing less than anxious scrutiny to the rights of a citizen who has lived here for a great many years. That's in AB Jamaica, my Lord. Moving from there, Yes, I should pick up on one point. There was a question put to my learned friend, which I must refer to in terms of the response given was fairly curious. Yes, it was a question from my Lord Hodge, who asked, in terms of the statement of Lord Bingham in EB Kosovo, could it be an issue of reasonableness? And my learned friend said, I accept it's reasonable in the circumstances, and it's a question of fair balance, but that's to be assessed by exceptional circumstances. Now, that is taking the ratio of EB Kosovo and conflating it with the disapproved ratio of Wang, and it makes a nonsense of the judgment in of itself. But the difficulty she truly faces, whilst we still have the guidance open, is that if it's a question of reasonableness, why then does the guidance at the bottom of 3275 say the assessment of whether there are insurmountable obstacles is a different and more stringent assessment than whether it would be reasonable to expect? It doesn't make any sense at all, that submission. And the acceptance, of course, has to be forthcoming, because my learned friend would prefer the court to not have to overturn EB Kosovo, because that would be a very uphill struggle, if one can put it politely. But aside from that, my Lord also asked, my Lord Wilson asked me to look into the issue of major impediments yesterday. And that is, having done some extensive research into that phrase, it appears from its reference in IAA versus United Kingdom, which is in the Appellant's additional documents.
Well, we saw those references in the recent case.
It was at paragraph, I think it was at paragraph 48 of IAA. But that
and elsewhere.
And elsewhere, my Lord. So, my Lord, that makes reference to the case of Ikuga Tekle at 48. And what we see at Ikuga Tekle at paragraph 48 is a reference in turn to Sen versus the Netherlands. That is where the phrase seems to have originated.
Thank you.
Now, none of the European jurisprudential database has any indication of that phrase, major impediments, being used in another Article 8 context. So it seems to be something that can be equiparated with insurmountable obstacles indeed. But what is more curious is the paragraph in which it originates from in IAA. And I turn to this because it turns the Secretary of State's case on its head. The page in question,
Do we have Sen, incidentally?
we do not, my lady, no.
No. I'm not really asking for it, because if I want to look at it again, I can look at it again. So, not more trees, please, but
We'll refrain.
if Sen is, you think, the origin of the major impediment
It is.
phrase, yeah. Thank you.
Forgive me, my lady, I'm just trying to find the paragraph number.
It's IAA you want us to
It
look
is IAA versus the United Kingdom, where there's...
588.
Thank you.
Paragraph 44.
Yep.
Yes, so...
Which page?
368 or 3588.
So yes, 3587 also, there is reference made, which is the paragraph I would ask the court to note in passing. Forgive me one more moment. The paragraph in question, yes, it's both actually. So it's 40 at the top of 3587 makes reference to major impediments and insurmountable obstacles first. It's then turned to overleaf at 44 at 3588. And the reason I'm drawing the panel's attention to this paragraph is this is because the Strasbourg court here have assessed the approach taken by the upper tribunal, which is on all fours, as it were, with EB Kosovo. So the approach taken, as it says, in the sixth line down approximately, however, and I look at the fifth word in, however, in considering whether the applicant's mother could reasonably relocate, the tribunal applied a lower standard than the test of insurmountable obstacles or major impediments commonly applied by this court. Applying its own test, the court considers, and then it goes on to make its own assessment. But the point I make is, even though the reasonable relocation ratio, as it were, was before the Strasbourg court, it was not disapproved as being anything less than the minimum protection that could be given under the convention. Were it to be a phrase or a ratio that is frowned upon and therefore departed from, as the guidance does do at the page I've just pointed to, it would surely be mirrored or matched by the Strasbourg court's most recent decision. So that is the reason I point to that paragraph of the authority.
Are you suggesting that in IAA, the Strasbourg court has espoused the rubric reasonable relocation in substitution for insurmountable obstacles?
I don't say it's a substitution. I simply say that it's a question of the domestic margin.
It's
the domestic approach.
They've observed what the upper tribunal did and said, well, we do it differently.
Yes.
It is an observation, but
it's not an endorsement, it's not it?
It's not an endorsement, no. I'm not saying that. But what I'm saying is that it's not to disapproval either.
What the court in IAA said was applying its own test,
Yes.
which it then identified as insurmountable obstacles are major impediments.
Yes.
So while it was saying that the tribunal was at liberty to adopt a lower test, the Strasbourg court's approach was to cleave to the insurmountable obstacles.
Yes. A harsher test as the minimum protection necessary. But in terms of providing the minimum protection necessary, what I was trying to show and illustrate is that it isn't said by Strasbourg that the test approved in EB Kosovo falls below the minimum threshold given in terms of the question of protection of a fundamental right. So if
That's
it
hardly
is...
surprising.
Forgive me?
It's hardly surprising.
No, it's hardly surprising. But
If
my lord,
Strasbourg has applied a higher test and domestic courts have applied a lower test, then they're hardly likely to condemn it, are they?
indeed, my lord.
Yeah.
But that is the point I seek to make. There's a discrepancy here then in the Secretary of State's approach. Why is it that she seeks to then depart from the test in EB Kosovo? There must be a reason for it. And the only reason she has given is the description by Mr. Justice Sales, as he then was, in Nagre, that it is a loose compendious summary of the authorities of Strasbourg Court. Now, as my Lord Kerr said yesterday, that's one way of looking at it, but it's a question for this court to decide whether the previous decision in the House of Lords fits that description.
But I mean, it's not part of the ratio of the decision, is it, or have I misunderstood it?
It's not a...
The observations in that paragraph are general observations, but they're not part of the ratio of the decision. It was all about delay.
Well, my Lord, I say, I respectfully submit, it's an example which hasn't been disapproved or hasn't been proven that it should not be followed in the questions of subsequent jurisprudence, either in terms of the domestic court, which would bind or overturn EB Kosovo's example, or in terms of Strasbourg giving clear examples where that is not going to be a provision of minimum protection. So it's a question of minimum protection. The whole reason why the domestic courts would follow the Strasbourg jurisprudence is under Section 2 of the Human Rights Act. It's to take account of what must be done to provide a minimum level of protection at international levels, which have been approved given the generality of approaches that the member states can follow. So that is the point I seek to make. On that same topic, in fact, if I could direct the panel's attention to Evans versus Attorney General, and that is at it's in the Appellant's additional volume as well, and the MS number is 3377. This does reinforce to a certain extent what I'm trying to say, and will hopefully make even more clear the discrepancy in the Secretary of State's position. At paragraph 56, if we can start there, there's an observation by the House in terms of the observation by Baroness Hale in Jackson versus Attorney General. The courts will, of course, decline to hold Parliament as unfair and interfered with fundamental rights unless it has made its intentions crystal clear. Then there's a reference, of course, to Lord Hoffman's judgment in Ex parte Sims. I say that's a very important reference because it sets out a passage which, in my humble submission, describes to a great degree the questions at stake in these appeals that are before the court. If I can leave the panel to read that momentarily. So in terms of maintaining the rule of law, it's clear that Parliament cannot move away from the rule of law. And indeed, I've gone to great pains yesterday to show that this is not the will of Parliament that is being pursued here in terms of the immigration rules. These are merely statements of practice. It is not even subordinate legislation, but just simply ministerial statements of what her executives will follow. So this isn't, as it were, a challenge to material of the legislative arm of the Constitution. It's a challenge to an executive statement, purely and simply. So with that in mind, turning then to paragraph 57 below, the statement from Lord Reid in AXA General Insurance is also important because it makes clear how, in terms of whether this were to be a challenge to legislation or even subordinate legislation, how clear and unambiguous the retrenchment, as it were, or the departure from a fundamental right would need to be. But the point is made even more clear then in Ex parte Pearson, below that, to the top of the next page. A power conferred by Parliament in general terms is not to be taken to authorise the doing of acts by the donee of the power which adversely affect the legal rights of the citizen or the basic principles on which the law of the United Kingdom is based, unless the statute conferring the power makes it clear that was such the intention of the Parliament. Now, what I say can be taken from that is if you cannot contravene the basic principles of the law of the United Kingdom, given that we have an unwritten constitution, we have a common law, and we have decisions of the senior courts, the curial hierarchy is binding on the lower courts. How can it be, given that, and given that the margin of appreciation is shared by the national authorities equally, by both the government as well as by the courts, to maintain the minimum protection of a fundamental right, how can it be that Parliament, in terms of the 1971 Act, intended, which I say did not intend, to give the power to the Secretary of State to adversely affect the basic principles of the law of the United Kingdom, such as that of Wang, EB Kosovo, Razgar? How can these decisions be departed from in this way? It cannot be simply by reliance upon Strasbourg jurisprudence, which one need only take account of under Section 2. For the Secretary of State's argument to succeed, it would mean that the court is implicitly doing more than take account of the Strasbourg jurisprudence because it is ignoring its own path that has been cut. If I can also then just turn back to jeunesse for a moment to make good another submission, and that is at tab 76 or volume 6.
Well, this preliminary argument is made on the premise that jeunesse has the effect which Ms. Giovanetti claims it to have. This first argument.
If I'm wrong on that, yes, this is, as it were, an alternate submission to address what we have heard. But on that point, just turning back to jeunesse and rebutting equally what has been said of it, if it is the case that jeunesse does reintroduce, as it were, a clear picture that there is a differentiation between positive and negative obligations, the paragraphs I've referred to in the table, anyhow, should therefore be wrong or should not appear in the judgment. That's 114, 121, 122, which we'll look at now momentarily. So those are at MS 2454. Sorry, 2453. So first we have 106, where we have the paragraph which originates from Armut versus the Netherlands, which was the first decision in our authorities, at least, that followed on from the dissenting judgment of Judge Martins and Gull. So we have this 20 years later still being echoed. Then, if we turn over to 114, the paragraph that I referred to yesterday, which my learned friend hasn't been able to address or rebut, which is that there is as it were, an intermingling here of two different thresholds. As we can see in the second sentence of the paragraph, the court must examine whether the applicant's case has exceptional circumstances which warrant a finding that the authorities have failed to strike a fair balance. So, is there an exceptional circumstances approach truly? When it comes to a non-settled migrant, it doesn't seem to be so, because it comes down to fair balance. Now, that is also echoed at 121 and 122 across on the opposing page. And this is a point that my Lord Kerr put to my learned friend yesterday, and in fact read back to her. The central issue in this case is whether, bearing in mind the margin of appreciation, a fair balance has been struck. Now, that is all I would probably need to say, to put in the simplest terms, to defeat the argument of my learned friend, but I've given you several different bases upon which the argument is flawed also. Turning from there, as a matter of housekeeping, to reply to certain facts that were in the written case, although I understand that my learned friend didn't have the time to address them. There were references made in the respondent's statement of case, roughly paragraph 20, I think it was, to the judgments of Ambrose, etc., and Alscaney. In terms of Alscaney, I would reply on Lady Hale's judgment at in paragraph 90 of that same decision, where my lady made observations regarding the vital importance of the distinction between domestic law and Strasbourg jurisprudence. I'll just turn to that momentarily, actually. There is time. Alscaney appears it must be in volume 2 at tab 22. Thank you, Mr. Chief Executive. So in terms of paragraph 90, that appears at MS number 809. So 809 and paragraph 90. What I would seek to highlight is the second part of the paragraph, which starts, while it is our task. So while it is our task to interpret the Human Rights Act 1998, it is Strasbourg's task to interpret the Convention. It's often been said that our role in interpreting the Convention is to keep step with Strasbourg, neither lagging behind nor leaping ahead, and again a reference to the Ulla principle. If Parliament wishes to go further, of course, or if the courts find it appropriate to develop the common law further, of course they may, but that is because they choose to do so, not because the Convention requires it of them. So that's a clear reference there to the fact of there being a distinction between taking account of and departing, I would say, inappropriately from one's own domestic curial hierarchy to prefer that of the Strasbourg jurisprudence, if there is indeed a difference. Now, this is a point that I would reply to in as neutral a manner as I could. My learned friend has played upon one of my submissions that there may be a departure from Strasbourg jurisprudence in EB Kosovo or Wang. That's not quite what I'm saying. What I'm saying is that one can see in Razgar, paragraph 20, that there is as it were, a collaboration of the de Freitas principles alongside the fair balance principle. Now, that doesn't mean that we are departing from Strasbourg, but in my respectful submission, it's improving upon the test that is imposed by the Strasbourg court, because one then takes a structured approach which is measured and has a pace to it and ensures that essential questions in terms of protecting fundamental rights of for example, family life here, are not ignored. Now, whilst my learned friend seeks to improve her client's case by making good on the interference limb of the Razgar questions, that completely ignores the fact that proportionality is done away with under the rules and the guidance. The guidance and the rules are, I should say this, because although my lords and lady haven't been through it in exhaustive detail as I have, it is quite surprising because it does not feature the word proportionality, it does not feature the word fair balance, it simply talks in terms of insurmountable obstacles and exceptional circumstances. Now, if this is truly a reflection of the Strasbourg jurisprudence, and if it is truly the rules are meant to apply to non-settled and settled migrants, why do we not see the terms used for 20 years by the Strasbourg court in the rules? And given my submissions on the domestic hierarchy in our English common law needing to be reflected by the executive and the margin of appreciation that the courts have in maintaining the obligation to not breach Section 6 as a piece of domestic legislation, because, of course, the schedule to the Act contains portions of domestic law, why are these not reflected in these executive statements and the guidance by which caseworkers are mandated to apply human rights? Now, an important point to remember is that the rules are a codification of human rights. Now, whilst the rules, as was said by Lord Justice Lawson, authority my learned friend referred to in the written case, I can't recall off the top of my head which one it was, but Lord Justice Law said that, of course, such decisions do not need to, such rules do not need to reflect human rights. That was before codification came along, and the Secretary of State decided to codify an entire fundamental human right into one piece of rules. Now, that is something which is, with I say with respect, turns the domestic legislation on its head and also ignores the fact that the guidance and the rules also don't take into account the important parameters in both domestic and Strasbourg jurisprudence.
It's not only the case that, of course, it is not the Secretary of State's case that the rules codify Article 8. The Secretary of State's case now is that the scheme is Article 8 compliant, which is a rather different thing. I think I've understood that correctly. But the point that I put to Ms. Giovanetti on the previous case is that there are plenty of people who do qualify to enter under the rules for whom Article 8 would not give them a right of entry. I mean, if you're rich enough,
Yes.
you come in whether or not Article 8 would give you a right to do so, for example. And Ms. Giovanetti is agreeing with me. So there is no way in which the rules can purport to be simply reflecting Article 8. They are doing something a bit different.
Yes, but I think in support of your point, if you actually look at the decision letters in this case, they apply the rules. They then go on to purport to apply Article 8 by reference to Rule 276 ADE and exceptionality.
Yes.
And your point is simply, well, 276 ADE plus exceptionality is not even a very poor mirror image of what Strasbourg requires.
Precisely, my lord. It is. But I do also take my lady's point that if the executive wants to be more generous than they need to be, that still doesn't allow them in other areas and for other persons in society to not give respect to their fundamental human rights by promulgating or putting into practice rules which don't give respect to the fundamental right. So it's of course open to her to be generous, which is somewhat surprising, but she also should be fair and also not contravene the minimum threshold of Strasbourg.
Well, do you submit that the approach to the question of whether the Article 8 right should be recognised by the Secretary of State is exactly the same whether or not the individual is an overstayer or a settled migrant?
I say that according to the Strasbourg authorities, they're historically, starting apparently with Abdulaziz at paragraph 68, although I've shown in terms of paragraph 67, it didn't apply necessarily to citizens. There seems to historically be an attempt at distinguishing between categories of migrants. And I've already pointed to my lady's judgment I think it was BB, where there was a third category as well of migrants. But if one goes down that slippery path, it does lead to different tiers of society or migrants by trying to distinguish between them, when it's simply a question of citizens and those who are settled or not settled, but settled in the immigration rules sense, that, say, for example, someone who has indefinite leave to remain, that is settled. But Strasbourg seems to go
Whether
beyond
one has
that,
to
as it were.
negotiate a slippery path or not, what's the destination?
My lord, the destination is that everyone has an entitlement to have their family life assessed according to fair balance as the minimum level of protection according to the Strasbourg jurisprudence.
Yes,
I
but that
pointed.
doesn't really, I think, address the question that I put to you. Is the approach to be the same, or do you say, well, it doesn't really matter whether you're a settled migrant or an overstayer, your circumstances have to be considered individually, and the status that you have is only one factor to be taken into account?
I say the approach should be the same. The status is not dispositive or even determinative of the Article 8 exercise. It's merely something that you would note upon the way in terms of balancing everything and reaching your ultimate conclusion. In formal reply to my learned friend's reliance on Ambrose versus Harris, I would direct the panel's attention to paragraphs 126 and 130 of that authority. I would say that Lord Brown's passages from the judgment, which my learned friend relies upon, could equally be said to be mirrored in opposition by Lord Kerr's passages. But there are various views, but it may not be dispositive or ultimately require the panel's attention anyhow.
Well, as was pointed out yesterday to Ms. Giovanetti, there is a difference between what the domestic courts might do in seeking to answer a question which Strasbourg has not answered or not addressed, which was the Ambrose and Harris situation, and indeed also the Rabone situation. So we've got Ambrose going one way and Rabone not necessarily inconsistently, but nevertheless seeking to see what Strasbourg would do if it got the case. And this situation, where we do have lots of Strasbourg case law dealing with the right to respect for family life in a variety of different ways. And we have to take it all into account and make what sense of it we can. But it's a very different situation from saying, well, would Strasbourg create, in effect, a new right? That's not what we're doing in this case.
No, this is not something new. This is well-tread ground here.
It's not an Ambrose and Harris type situation. I'm not sure you need to answer it, is what I'm getting at.
I'm grateful, my lady. What we would say is this is a clear departure from previous authority without good reason, in simple terms. It's well-tread ground, and it hasn't been shown that the previous authorities, such as Quilla and Beebe, are wrong in terms of how one should treat migrants. If I can briefly turn to some of the final points I do need to raise, but I'll pause for one moment. There is one observation I would make in terms of just one final point. I don't want to hammer the positive-negative obligation argument much more. But if my learned friend is correct in terms of interpreting jeunesse, that it's a question of interference, all I would say is that's not reflected in the jeunesse judgment itself. There isn't an explicit example, as it were, of the Strasbourg court following that structured approach and saying, is there a question of interference here? There is the standard paragraph that we have seen habitually since Rodriguez, but thereafter there is no adventure into the territory of considering the competing arguments. So I would say that the ultimate conclusion reached a fair balance clearly prefers the traditional territory of conventional proportionality. Which takes me to the authorities of Wang and also Bank Mellat, which is also in the authorities before the panel. And what my Lord Reid said does echo, in Bank Mellat, does echo what Lord Bingham said in Wang. That is a question of approaching the situation of a fundamental right is to be approached in terms of the proportionality assessment. It is a structured approach for a various reason. And if it's something which has held good over millennia, since Aristotle's times, for example, it shouldn't be said that now it's to be departed from because there is a potential theorem that Rodriguez suggested there's a difference between how one should approach various persons in society. That turns the question of society on its head, as it were, and also distinguishes the right to respect for family life depending on who you are and where you are in society. And as I've said, that's a very sticky question, which I invite the court to reject entertaining.
What might be said, I think, about Bank Mellat is that when, in that case, the fourth criterion of fair balance was analysed by Lord Sumption and myself, we both analysed it in a way which effectively incorporated the earlier stages of the analysis, in that one was balancing. What one was balancing was, on the one hand, the extent to which the action or inaction, as the case might be, of the state was going to achieve some public policy goal in the public interest, on the one hand, and on the other hand, the impact it would have on the protected interests of the individual, and that meant one had to identify what the aim was that the public interest was concerned with. And also clearly that there be a rational connection between the measure and the aim.
Yes, my Lord. That's forgive me if I'm speaking before the question's posed, but my Lord, that is precisely what I say, and that must be the reason why my Lady Hale asked the question. What's the reason behind this? Because no one has ever said one should be discouraged from marrying a foreign migrant, particularly someone who's an overstayer here. So it turns it begs the question of rationality, and it's clearly an irrational stance to take if one is simply using the excuse of following Strasbourg jurisprudence but then failing to do so miserably. There is one authority also I would direct the panel's attention to just before I close, as there is some time still left, which is that of In Re G, the adoption case, because it raises and reinforces a certain point as well. That is to be found in the appellant's additional documents. It starts at page 93 of that bundle, but the particular passage I direct the panel's attention to is, I think it's at paragraph 33, if memory serves me correctly. And that is to be found at MS number 3325, and there is, I already gave the passages of paragraph 30 to 38 collectively because they raise the Ulla principle, for example, and seems to be an underpinning for my learned friend's case. But I would draw particular attention to paragraph 33, for example, because it makes clear the distinction between convention rights and domestic law, which I've already tried to illustrate by referring to Evans versus Attorney General. And of course it says here that, as this House confirmed in McCurr, within the meaning of the 1998 Act are domestic and not international rights. They are applicable in the domestic law of the United Kingdom, and it is the duty of the courts to interpret them like any other statute. When 6.1 says it's unlawful for a public authority to act incompatibly, that means the domestic rights set out in the schedule to the Act and reproducing the language of the International Convention. So it's a question of domestic binding authority as well, and statute. Turning from there then, I will close by making a few bullet point remarks on what I say should be the highlights, as it were, of this appeal. In terms of the rules, our submission would be that they are clearly not legislation or subordinate legislation. They are statements of authority from the executive. I've illustrated how the rules were not perhaps put through the usual scrutiny as they might be, even by the weak form of negative resolution procedure observed by Lord Hope and Stillato. For example, I gave the example of 40 days being given before these rules take effect normally, and it was 26 days on this occasion. And there not then being the opportunity for full debate and democratic approval anyhow. And also in terms of the report not being compiled perhaps by the scrutiny committee and being put to the House so that the House could understand the grave implications that are portrayed, and I say revealed in my submissions in terms of the rules and the guidance. In terms of the positive and negative obligations under Article 8, my submission would be, as it has been throughout, that there is no differentiation here. I've pointed the panel to 20 years of authority, which shows that fair balance is the outcome that rules the day after Gull versus Switzerland. In terms of the domestic approach, it has always been that there will be no need to differentiate between the two approaches. That's made clear from Quiller and Beebe as well, which my learned friend is forced, of course, to challenge. I also say, relying on AG Eritrea and VW Uganda, that it's a question of it needing to be simply more than a consequential or a technical interference. If there needs to be a test, that is the test that was binding until we've heard this argument now today. In terms of whether the rules closely track Strasbourg jurisprudence or not, it's clear that they do not. That as much seems to have been accepted by my learned friend because the insurmountable obstacles criterion has been elevated from one factor out of many that Strasbourg will consider, and it has been picked out of that basket in preference to all the others. The others have been thrown aside, and this has been made into a sole test by which non-settled migrants must succeed, and also, quite unattractively, which settled migrants must also succeed under if they do not meet the eligibility criteria, such as perhaps losing their job or their home. So that is obviously not an accurate reflection of the Strasbourg jurisprudence. The problem that that leaves the Secretary of State with is that when she then tells her caseworkers and mandates them under RLTRP 1.1d to refuse the application because there are no insurmountable obstacles, then when that stigmatized mind of a caseworker will turn to exceptional circumstances in the guidance, they are then told this must of course be something which is unique or genuinely exceptional, extremely rare, and all of those parameters are used, generally speaking, in the statement of intent and the guidance. But the guidance makes clear that it has to be something which is over and above that already canvassed by the rules. That is also made clear from the Court of Appeal below, and that is why the parameter has been reintroduced in the past 2 years or so of exceptional circumstances on this proposition, which is clearly flawed, because the exceptional circumstances criterion, as we can see, is not a minimum threshold to success applied by Strasbourg. It's a phrase used, a descriptor, in various authorities. But as we can see from the most recent authority where the phrase is used in Jeunesse, it seems to be on the pathway to a fair balance exercise anyhow. So it begs the question of whether the original challenge in terms of Wang and the exceptional circumstances threshold is right even now in hindsight. It seems to be even more erroneous than it was at the time, given that decision of the Grand Chamber in Jeunesse. In terms of then the approach to British citizens, I make my position clear that first and foremost the authority of AB Jamaica and VW Uganda have made clear that one should give anxious scrutiny and great attention to the rights of a British citizen before it can be said that they should leave the United Kingdom. The guidance on that point makes it clear that the citizens' rights are not to be considered an insurmountable obstacle because of the manner in which the exceptional circumstances guidance is drafted. It means that that won't be taken into account anyhow afterwards in terms of the residual discretion. That also means that the rights of the British citizen partner are never taken into account under the current regime. And that also, I say, is something which is offensive to the Zambrano ratio itself in terms of there being an obligation upon the citizen to depart from the EU. It's clear from the manner in which the guidance is framed and the rules are framed that if you don't meet our criteria, you should up sticks and leave and move halfway around the world, whether you wish to or not. Turning from there to briefly to the Immigration Act 71, it makes clear in Section 1.1 and Section 2.1 that, of course, citizens are not subject to immigration control, and therefore the Secretary of State has no right to presume their choice would be to leave without perhaps knowing what the choice ought to be. In terms of precariousness, and the manner in which it's looked at, it's clear from Jeunesse, which also looked at precariousness, and also EB Kosovo, that precariousness is not a fixed quantity or measure. It can, of course, diminish according to the passage of time and the ties put down here by the migrant over that passage of time. This is, of course, paragraph 15 of EB Kosovo, because that is something which Lord Bingham said is a reality of the lack of the removal of the migrant here. And of course, that is a very special occasion on which Lord Brown and Lord Bingham both agreed on that point. In terms of the domestic authority, also on the unjustifiably harsh descriptor, we've heard that there was no origin for that phrase at all, and it has already been disapproved, as it were, by the Inner Court of Session in Scotland. So I would encourage the panel to approve that decision in turn. In terms of the pro forma nature of the refusal letters, I have pointed the panel's attention, although briefly I do apologise for that, in terms of the wording that is used. We can see that the wording in these particular decisions is entirely pro forma. It's a copy and paste exercise, if I can put it politely. There hasn't been any evidence whatsoever of the various factors underlying the application being grappled with on a conventional proportionality approach or a fair balance approach, which is, of course, the final limit in conventional proportionality anyway, so in contravention of domestic and Strasbourg jurisprudence. I won't address you on the Jaquamba point, because if I'm right on all of these points anyhow, then it may be that it won't come to bear. But I'm grateful for your patience and attention. Those are my submissions.
Thank you very much indeed, Mr. Saini.
And I hope to have a junior on the next occasion.
Well, we will hope to see you with the assistance of a junior in
grateful, my
due
lady.
course. Yes. You have battled on personally, and we're grateful to you. And we're grateful to everybody else who's contributed. We know that lots of other people have played a part in the arguments that we have heard, not only in this case, of course, but in other cases which are on related subject matter. And we will now go away and put our thinking caps on. And you will hear from us further in due course. The court is now adjourned.